right, sir, are you Howard Celeststeine?
Yes, Your Honor.
And Ms. Prazo, will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
Mr. Celeststeine, in cause number 24 DCCR 0919, you're charged with a third-degree felony offense of manufacturing or delivering a controlled substance from January 10th of 2024. That indictment alleges that you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th of 2009.
Right here, the judge lays out a bombshell of prior conviction for aggravated sexual assault of a child. This changes everything. It means any new charge automatically becomes more serious under Texas law. Viewers, do you think repeat offenders deserve a second chance, or should the past always weigh this heavy?
And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily,
Yes.
and because you did what they charged you with?
Yes.
And is that prior offense true, that prior conviction? The one that I read out, the aggravated sexual assault of a child, is that true, that is a prior conviction of yours?
Yes.
Okay. And cause number 24, DCCR 1549, it says count one only, but then it says a 20-year term, so it has to be count one and
That's
two.
right, that was my intent.
If it's
That's
20,
correct.
count one and two.
Yes.
Okay.
Oh,
There's only one prior.
right.
So that's what makes that third degree turn into a
The
second.
second degree. Okay. Sorry.
So pleading on count one would only be to the underlying offense.
Right.
Okay, so in 24 DCCR 1549, you're charged.
Notice how calm his answers are. Yes, yes, it's chilling when someone pleads guilty to crimes this severe without hesitation. Sometimes in court, silence and simplicity hit harder than any argument. What do you think? Is he resigned to his fate, or just detached from the gravity of his actions?
With a second-degree felony offense of aggravated assault with a deadly weapon from June 24th of 2024. The indictment alleges that same prior conviction from April 13th of 2009. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And again, is that prior conviction true? And did you enter your plea of guilty in this case freely and voluntarily?
Yes, Judge.
And because you actually did what they've charged you with?
Yes.
So in cause number 24 DCCR 1550, you're charged with a first-degree felony offense of murder from June 24th of 2024, and the state's elected to proceed on that count only. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily,
Freely.
and because you did what they charged you with?
Yes.
In cause number 24 DCCR 1551, you're charged in that case with the state jail felony offense of abandoning or endangering a child from June 24th of 2024. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily,
Freely.
and because you did what they've charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Perazo?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney, you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Celeststeine is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true in the cases that you did freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas in each case. In cause number 24 DCCR 0919, find sufficient evidence to find you guilty, and at this time find you guilty of manufacturing or delivering a controlled substance. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1549, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon, find that prior conviction true, sentence you in accordance with your agreement to a term of 50 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1550, find sufficient evidence to find you guilty, and at this time, or find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder, sentence you in accordance with your agreement to a term of...
Now, this part is crucial. All his sentences will run concurrently, meaning he serves them at the same time. So instead of stacking decades, it caps at 50 years total. The judge also makes a deadly weapon finding, which limits parole eligibility. Essentially, he's not walking out anytime soon. What's your take? Fair justice, or a light sentence for multiple crimes?
50 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24 DCCR 1551, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child, sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I am making an affirmative finding of a deadly weapon in cause number 24 DCCR 1549. I'm handing you in all of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff.